Legal Matters.
So happy Africa Day to you. We'll talk about that too, Africa Day. Advocate Tertius Wessels joins me now, Advocate and Legal Director at Strata-G Labour Solutions. Advocate Tertius Wessels, good evening to you and thank you so much for joining us.
Good evening, Aubrey, and good evening to your listeners, and thanks for having me.
So the Employment Equity Bill is undergoing some changes. Tell us about this, Tertius.
Yeah, so I think what's important to note is that the Employment Equity Act sought to promote affirmative action and equal opportunity through the elimination of unfair discrimination in the workplace.
Yep.
And despite these efforts, many private sector companies remain untransformed, so to speak.
Yeah.
And historically disadvantaged individuals are still unrepresented in senior skilled positions. And so back in July of 2020, the Department of Employment and Labour published the Employment Equity Amendment Bill. And the main purpose of these amendments is to enable the Minister of Employment and Labour to set and regulate sector-specific employment equity targets and to ensure that employment equity compliance certificates is a prerequisite for accessing state contracts. And I think this is all as a means to try and just ensure that there's a quicker way in which businesses are actually transforming, because I don't think transformation has been quick enough if you look at the history.
Okay, let's talk first about the Employment Equity Act as it is at the moment and whatever amendments that are proposed. And let me put this question to you and say, could it be that part of the reason why we haven't seen the transformation of various sectors in this country is because of that age-old South African reality that we've got great laws, great policies, but we've got very weak implementation, and in this case, enforcement of some of the acts that are in that bill?
I think you're 100% correct if we look at it from that perspective. You know, our laws are very much aimed at achieving the right objectives at the end of the day. But it is a question as to whether or not we have the capacity in order to ensure compliance with the necessary legislation, and whether or not we have the means, so to speak, in order to ensure that we are able to achieve these objectives of the legislation. Because everything is great in as far as it exists in writing, but it's often the application, the implementation, and the monitoring, the compliance with that legislation that ultimately will determine whether or not we are able to achieve those objectives. For a long period of time, many have viewed the employment equity as a so-called tick box approach, much like BE. And it's simply because there is not enough capacity as it stands to ensure that employment equity in its current form is being adequately complied to. And I don't think that non-compliances are necessarily dealt with in the manner that it's supposed to. So a lot of people aren't really taking the measures of the Employment Equity Act seriously in itself.
So when we talk about the fact that there's going to be an amendment to the Employment Equity Bill, and I suppose all of that is aimed at further deepening the, speeding the process of transformation. If we haven't dealt with the provisions of the Employment Equity Amendment Bill in the first instance, what is the thinking behind what is going to cause for the adherence to the amendments going to be? Why do we believe anything's going to happen at that level?
So I think the intended implication of the proposed amendments are quite clear. Designated businesses, which effectively in terms of the new definitions will be any company with more than 50 employees, will no longer be given any space to set their own employment equity targets. And they will be required to comply with sector targets that will be set by the minister as he or she deems fit. And moreover, there's a penalty for non-compliances, especially for any business that's doing work for the state. Companies that are unable to meet the minister's requirements, which at this stage is unknown, will effectively be barred from doing business with government. And for large and established businesses whose employment profile is not yet representative of South Africa's national or provincial or sector demographics, these amendments pose a significant risk. But yes, then again, the question still arises, if that certificate of compliance, so to speak, is not issued, it has a potential detrimental impact on the businesses. But the question that I still ask is the capacity of the Department of Employment and Labour to actually define what would be appropriate targets. And if there are any delays or disputes regarding the issuing of these certificates of compliance, to what extent will it impact on the effectiveness of the entire public procurement system, so to speak?
And I suppose the last concern is, if there is no compliance, what will happen? Because I think as you started out, Tertius, by pointing out that, well, we've got these laws, they're great. They are here to try and bring about transformation and bring about the equity that we all desire and so forth. But when people don't comply and government doesn't have the appetite, the capacity, nor the vuma to actually make sure that there's compliance through enforcement, why should a company that is untransformed actually transform?
Yeah, and I think that's the issue here is about that implementation. The law, the Employment Equity Act, I think it was for the first time amended back in 2014, and there were a number of provisions that were revised that enabled the Department of Employment and Labour to approach the Labour Court for immediate imposition of financial penalties on designated employers on the grounds of non-compliance. And the amendments now, the Department of Labour is entitled to impose financial penalties through the Labour Court without giving designated employers the opportunity to remedy acts of non-compliance. So very often what we see when the Department of Employment and Labour goes out to businesses in order to conduct an ordinary labour inspection or an inspection in terms of employment equity, is to identify areas of non-compliance, then normally giving the employer an opportunity to rectify those non-compliances. And then in turn in writing confirm that it's been attended to. Now these fines that we're now talking about are directly proportionate to a number of previous contraventions and timeframes. For first offence now, a fine of 1.5 million or 2% of a company's turnover, depending on which is greater, can be issued. And obviously, again, there is this whole issue about contracting with the state. Fine, yeah, and I mean,
do you know, Advocate Tertius Wessels? Do you know of any company that has ever been fined for non-compliance?
I know of many companies that have been threatened with specific fines, and where there has been a threat of engaging in litigation. And the other reality is that for many businesses, 2% of their turnover might not seem like a lot for them. So if they are able to utilize the opportunity that they have to engage in a so-called email litigation with the department, to avoid and drag out a process, that's a lot quicker. Litigation is not as expedient as one would ordinarily want it to be. And it takes time for those processes to unfold. And eventually you might find that a business opts to either simply pay the penalty, because their ability to be compliant is, it's either not there, or they feel it's unfair, or whatever the case may be. So often you might just end up paying the penalty, or at certain points, after dragging it out long enough, ensure that you're now in a position to be compliant with whatever non-compliance notice was issued by the department.
But the direct answer to my question is that you only know of people that have been threatened.
None of the employers that we have been representative of has been fined. Let's put it that way. So either we're doing a good job.
Yeah. Let's talk about the amendments to the bill that have been proposed. Let's talk about them. The substantive changes that we can expect, and what the threats are, and what the levels of compliance are likely to be. What is the Employment Equity Act Amendment Bill suggesting now?
All right. So there's quite a number of important amendments that are being proposed. So I think if we look at the Employment Equity Amendment Bill, and more specifically what the purpose of it is first and foremost empowering the Minister of Labour to determine the sectorial numerical targets for the purpose of ensuring equitable and suitable representation of qualified people. That's the one. Yeah. Enhancing the administration of the Act, so to speak, which provides for this issuing of a certificate by the Minister confirming an employer's compliance with the Act, and the conclusion of state contracts. And then also there's a provision removing the requirement for psychological testing and similar assessment of employees, which ordinarily under the old Act needed to be certified by the Health Professionals Council of South Africa. And then also removing a provision regarding non- or designated employers and employers' ability to voluntarily comply with the Act in as far as it relates to affirmative action measures. Now, I think maybe the first point to address is this amendment to the definition of a designated employer. So,
well, before we even get to that, so you're saying to me that in terms of the amendments now, the power to decide on equity targets is going to fall on the minister, whoever he might be or she might be at any given point. That power will fall in the hands of a politician?
Yes. So the amendments proposed to specifically Section 15 of the Act
Advocate Tertius Wessels.
These numerical targets. Whether or not, and I think that's where a lot of the debate is now coming in, is because it's sharply in contrast with the current situation, where employers are able to set their own targets as guided by the racial distribution of the economically active population. And now the minister can now prescribe his or her own criteria for identifying a sector or subsector to be targeted, and he or she can set targets based on any relevant factor. The concern is that there is no guidance in the Act as to how the minister will set out such targets.
I hear that. But what you're saying to me is that part of the amendment to the Employment Equity Act is that an individual, right, whatever powers may be vested upon that individual, will have the power to say to a company that if you do not meet these particular criteria, then you may not be allowed to participate in the commercial life of this country. Is there no danger in that scenario of people's whims being used to settle whatever scores they may have, or to become proxies for competitors? Do you see what I'm trying to say? Shouldn't there be a situation where the criteria are set by a set of laws? In other words, us being a constitutional democracy, we ought to be guided by laws, not that a particular individual can decide on the basis of whatever whim that they have at any given time what the guidelines should be.
Well, Brian, I couldn't agree with you more on that issue, and I think that is, and we can only be hopeful that the relevant business, especially businesses that entered into and made use of the opportunity, because there was a process of allowing for public consultations, I think, which ran up until March of this year, for people to give their input, give their feedback, and raise their concerns in respect of this legislation, because it is absolutely extreme if you think that the degree of discretion given to the minister to define an economic sector and to then set targets for that sector, occupational level or region that's impacted by that sector on a basis of any relevant factor is just extreme. It just doesn't make sense at the end of the day. For a lot of times, we have officials that are responsible for enforcing the legislation, but you can't be the rule maker and the implementer. It's almost like being a judge and jury at the same time.
Absolutely.
And
look, Tertius, I understand. I mean, the current situation at the moment where companies are completely non-compliant, completely ignore the vision and the mission of the Employment Equity Act at the moment because of a lack of enforcement is also deplorable. But for me, this sounds like a swing to the other extreme that is going to either create a very draconian environment where people are going, or a minister is going to be able to have that kind of power. I find it dangerous.
100%. And look, and that's why I'm hopeful. And can I make matters worse for you?
Sure.
Or another concern that gets raised is that the minister is expected to table the bill for debate and then ultimately approval in the National Assembly later this year. And given the ANC's dominance within Parliament, the bill will likely be passed and will then be submitted for the President for his assessment and signature. And at this stage, I anticipate that there are numerous court challenges that are likely to be launched, which may delay the introduction of these amendments into law. And it's all because of this whole discretion that has been granted to the minister. Yeah. I think for the most part, many people welcome certain changes that are being proposed by the amendment bill. But this is one of probably the most controversial aspects, is this discretion that's given to the minister. And it will undoubtedly result in litigation in one form or the other.
Give us a call, 011-883-0702, as I speak to Tertius Wessels, Advocate Tertius Wessels, Legal Director at Strata-G Labour Solutions, as we talk about the amendments to the Employment Equity Act. Yeah, and I'd really like to hear from employers about these changes that have been suggested. Here's my issue, Advocate. One of the big problems that our Constitution is having is that it never envisaged that those to whom power was given would actually abuse it. We all thought that every leader would be a Nelson Mandela, And then we discovered that, in fact, by giving too much power to certain leaders, there is room for the abuse of that kind of power. We didn't envisage that at some point we may have leaders that can take the powers that they are given by the Constitution, by our laws, and abuse them. So haven't we learned our lesson in this instance?
I don't think that we have fully comprehended or learned our lesson as far as that's concerned, And there's a whole or age-old saying, with great power comes great responsibility. But unfortunately, we are sitting in a situation where many of our custodians, so to speak, are misusing and abusing those powers. And it becomes, and I think that's the whole issue, and I think it's a general issue that we often experience with the legislature, is that we have these wonderful laws that exist. For most part, many countries regard our constitution as one of the most, well-drafted, most supreme laws that exist. And it's all great and well to have these rights, but it comes to the implementation of those rights, the recognition, and what will actually work, and without leaving any scope for potential abuse, misuse, etc. And, as much as we create a scene, as much as we point out and make reference to various other instances where people in power have abused the power that's been given to them, we're still we're still drafting legislation that is kind of making provision for those things to continue. And that is where the concern is. And I think that we often underestimate as a society and the public as large as to what role we can play in having a say in whether or not these kinds of legislations get passed at the end of the day. I mean, the outcry that there has been towards the proposed changes to gun laws, where people now potentially might not be able to have a weapon just for the purposes of self-defense. I mean, I literally in a matter of 2 days, I have seen petitions come to light. I have seen so many things where people are now actually standing up and questioning the purpose behind it, etc.
Yeah.
But when it comes to other legislation that also impacts our daily lives, and for the most part, we spend most of our days in the workplace. When it comes to those kind of legislation, we kind of sit back because we just expect it to be what we think it is, not understanding that we actually have an ability through these processes to make a change.
Yeah. See, I agree with you. I think maybe there needs to be a very, very serious conversation around our understanding of citizens' involvement at various stages of the democratic process. But I suppose for me at the moment is just to try and get a sense of what the Employment Equity Act Amendment Bill is going to say. And I've invited people to call in to let us know what they think of some of the changes that we may see. In the beginning of our conversation, I set up a conversation to see whether or not there is enough compliance and whether there is enough enforcement of the current Employment Equity Act. It appears that lacks at some level. There's not enough enforcement. And that's probably part of the reason why there is no compliance. But it looks like the amendment that is being proposed swings to the other side of the pendulum, where it gives maybe too much power to a minister. And I'm concerned about that. I'd love to hear your thoughts as we go through some of the changes that we need to be aware of. Keith is in Mitchell's Plain. Good evening to you, Keith.
Very good evening to you. I know I listened to you in the evening as I was sitting down here. And the one thing that I agree with the gentleman, and I agree with you, we got the best laws in this world, in the country, the best, no enforcement.
Yeah.
The moment you make such draconian laws, we're going to scare off investors. I know people say we don't need investors, but we need people to invest in money in an environment where there's no draconian laws. There's a couple of laws that's going to happen. A, the police have cut down on the law enforcement, but they've increased the protection services. They take away the guns from people. The other thing is transport is the worst of all. They got the best laws. A, you cannot drive your vehicle with passengers unless you have a registered permit. The permits are issued, and government's got a layout there that once you apply, within 90 days you should get an answer to say, yes, you can get a permit, or no. People are waiting years. We can't enforce that or get that right. Why do we want to make laws difficult for people to create jobs?
Why do we want to criminalize people that are that are doing the right thing, I suppose, is the question we need to ask ourselves. Keith in Mitchell's Plain, sure. Gregory in Centurion, good evening to you.
Rob, good evening to you.
Yeah, go for it, Greg.
Rob, every year the Employment Equity Commission comes to you and they tell you that corporate South Africa is not playing ball when it comes to employment equity.
Yeah.
This happens every year.
Yeah.
Right? And every year there is an outcry as to why government is not doing more to make sure that there is employment equity, to make sure that black people occupy the highest echelons of management in this country.
Yeah.
This happens every year. Now, there was an outcry and government has responded. Why are we complaining when government is responding?
Well, here's the answer. Here's the answer to that question, Greg.
Okay, all right.
The answer to that question is that the response to that outcry is wrong. The response to the outcry should be then enforce the law. The law has got recourse for those people, those corporate companies that are not complying. That enforcement has not happened. I just asked Advocate Tertius Wessels how many of the people that he deals with have actually had to face the might of the law for non-compliance. All of them have been threatened with it, but there has not been enforcement. And our immediate knee-jerk reaction is to then change the law. I'm saying don't change the law, enforce the law.
My contention, Ops, is that even the current sanctions are not tough enough. We can debate about the implementation of the enforcement. I agree with you on that point, but I think there must be a stronger deterrent. And let me make an example here, Ops, because I'm from the construction industry and we are actually currently seized with this very same issue.
Yeah.
In 2017, we negotiated the construction sector code and we agreed that there are going to be certain targets to reach as far as employment equity is concerned. Today we are sitting in 2021 and none of the big companies that will have this law applied to them are compliant. Now they are pushing back because they have gone to sleep. After we agreed the target in 2017, they did nothing. Now they wake up in 2021. Government wants to enforce the target, and now there's a problem.
But that's because, Greg. That's because government was asleep to begin with by not enforcing the law when those companies did not play ball. I'm suggesting here that what we are doing is that we are swinging from one side of a pendulum to the other without having tested the power of the current laws to be able to make sure that those that don't comply are punished. Now we are saying...
My argument, Ops, is that when you look at what government is currently proposing in terms of punishment, in fact, I think this is a much better way of punishing companies by making sure that, for instance, they do not have the necessary clearances to do business with government. In fact, you and I can even monitor that, because if a company that is competing with me for a government opportunity does not ensure that it transforms, it means that it must not be given an opportunity to do business with government. And if you say that's killing those that are doing the right thing, I want to contend that it is not, because I'm also doing the right thing and I'm complying with the law.
No, I think we don't disagree there, Greg. My issue, though, is that here we are changing the law once again when we haven't tested the current law in terms of our ability as government to be able to apply sanctions on those that are non-compliant. We simply haven't punished those that are non-compliant, and now we're changing the law. I'm saying to you that if we weren't able to see compliance in the first instance, why do we believe that we'll see it in the second instance? And secondly, when we give the power to the minister, maybe the current minister is a nice guy, but what happens when the next minister is bought by large corporate companies to be able to favor them because that particular minister at that particular time is a bad guy? I'm suggesting here that we haven't given the current laws a chance to sting because we just don't have the balls to do it.
I'm suggesting, that what is being proposed, I think it's a much better tool to punish those companies. as opposed to the current tool. I think what is being proposed now is a much better tool, Bra Ops.
Greg in Centurion, thanks very much for that. Advocate Tertius Wessels, I think at the end of the day, what we all want to see is transformed companies, because we understand the economic imperatives and the flows that come out of that. All of us want to see that. But I think where we disagree is whether or not we need new laws or we need enforcement of compliance. I think that's where the big issue is. Your thoughts about that?
Yeah, I'd 100% agree with you, Aubrey, in the sense that we all understand the purpose behind the legislation. We all want to work towards an environment of achieving an equitable and fair work environment. But the problem is that there are various, there's cost implications, as one of the callers had mentioned, potentially scaring off investors, etc. Because cost implementations are impacted not only by the general scarcity of skills in South Africa, but in many instances you now might find that positions are left vacant if a candidate of the right profile with the matching qualifications cannot be found. And in those sectors and professions where the availability of skills is limited, companies now might end up paying higher recruitment, higher wages in order to satisfy their employment equity plan. And for a lot of people, the cost of doing so, they might not consider it worth their while.
Yeah.
And a lot of the problems ascribed to employment equity in South Africa does not stem from the legislation itself, but rather from the poor implementation of the Act. When implemented diligently, employment equity can be a powerful tool for designated employers to transform and upskill their workplace. But if it's not aligned, and if we now want to simply implement measures as a means to speed up transformation in the workplace without properly having thought it through and the application of it, it's going to cause us more problems down the line. It's only going to result in the legislation being challenged, court case after court case after court case, until the matter eventually reaches the Constitutional Court, and for the Constitutional Court then to pronounce on the validity of a particular clause in the legislation.
Look,
then all we are doing is we're delaying what could have been more properly dealt with.
Yeah. Look, and I suppose we will do what we believe needs to be done at any given moment. But I'm seeing a repetition of all of the issues that our government has failed in. The distribution of land, the whole land reform issue has not necessarily been because there's no land to redistribute, or it's because the laws have not been enforced. We've got laws in this country. They're there. They have not been enforced. And I fear that once we start changing the laws without having enforced the current laws, it's just going to be yet another delay process for a very, very important situation that we need to see happen in this country, and that's the transformation of our companies. I'm sure there's a whole lot of other things. We have 5 minutes, very, very quickly. Advocate Tertius Wessels, what are some of the other changes that we may see in this amendment?
So I think one of the amendments that I think is worthwhile mentioning, especially for your SME businesses, is a proposed change as to who will be regarded as being a designated employer. So in terms of the proposed amendments, who will be regarded as a designated employer, where it's currently any business with less than 50 but meets certain turnover thresholds, that will be repealed in terms of the amendments, which means regardless of your turnover, if your employment is less than, or your workforce is less than 50, you will no longer be regarded as a designated employer and therefore not required to comply with the provisions of the Act and as far as it deals with affirmative action measures. And it also does away with that portion of the Act which allows for people to, on notice to the Director General, voluntarily comply with affirmative action measures. So I think that will be a welcome relief for many small businesses who feel that there's already so much administrative or regulatory burdens placed on them. And, coming out of COVID, those businesses are already struggling to a certain extent. And for them to comply with these additional requirements, I think they would see it as a welcome relief at the end of the day.
I want to take just one more call. Nomonde is in Brakpan. Hi, Nomonde.
That's right, yeah. Audrey, all I want to say is that for 27 years, the ANC has become this think tank that comes up with laws, acts, and measures that they have not been able to implement. They think they're still a political organization. They are in government. They're supposed to implement what they come up with.
Sure.
They've not been able to do that. That's why the country is in touch. Show me one thing or one structure that is running well in this country. No, you will not find one. But if you can name one, because they come up with these ideas, acts, and measures, and they've never been able to implement one of them.
What is going to stop an unscrupulous CEO of a multinational company from buying Minister X a Mercedes-Benz in order to look away if the discretionary powers are solely vested in that minister? And I'm saying that, Nomonde, what this does is that, one, it just creates a mockery of the idea for transformation of our companies, because then it's definitely not going to happen.
Well, that's what they want anyway. Yeah. They've got billions that they're setting up right now, and they're excited, but all they're excited about is because they want to eat that money for themselves and their families only.
Nomonde in Brakpan, I couldn't agree more. Listen, I think we've got too much evidence in this country of not only the dropping of the ball, but the willful dropping of the ball at the expense of the projects that we all know need to happen in this country. To vest that kind of power in one individual, however nice he might be, is dangerous. It's actually putting that particular person in harm's way, because that particular person is going to be tempted in ways that you and I can't even imagine. And, if history is anything to go by, our government ministers have not done very well in resisting the kinds of temptations that come their way. That's why we find ourselves where we are. So, Advocate Tertius Wessels, I hear you. Thank you very much for giving us the education around some of these issues. But I don't know. When do we expect the amendment to become an act, the bill to become an act?
But it will probably only be tabled towards the later part of the year. But, there was so I anticipate if it's not later this year, if it's only going to be tabled later this year, it's probably only going to come into law during the course of next year. But, the Chief Director of Labour Relations from the Department of Employment and Labour made a public statement a while ago indicating that the department does not intend to delay the process of implementation. And I have a quote, we are already busy with negotiations with different sectors in terms of the targets. We are not waiting for the ball. The process has started already. Advocate
Tertius Wessels, thank you so much for joining us. Advocate and Legal Director at Strata-G Labour Solutions. How do people follow you, Advocate?
Aubrey, we are on Facebook, we are on LinkedIn, so people can follow us there. They can follow the company. Strata-G, that's STRATA-G, or they can just find, and if they type that in, Facebook, our website, or LinkedIn.
Thank you very much for your time, sir. Advocate Tertius Wessels.